In this video, we break down the real cost stack behind transferring a property to beneficiaries, children, other relatives before you pass away. So the first thing that we need to answer is, why would one do this? Now, there's a variety of reasons, but I must mention that if the only reason is for tax, please be very, very careful. Tax planning has to be fluid. Tax planning has to allow you to change your position if and when necessary. Why? Because if it's too rigid and it goes against tax legislation, it's very difficult to restructure. And remember, tax legislation is fluid. It's very dynamic. It's consistently changing. So you're going to back yourself up into a corner if your structuring is too rigid, right? So although it's one of the components, it cannot be the only component. So what are the other two components? Asset protection and financing optimization. Those always come to mind when you speak about structuring. Now, the one thing I need to mention before I speak about why people would want to do this is I'm not referring here to the transfer of residential property, so the sale of residential property. Why? Because there are certain benefits there from a capital gains perspective that we're not going to look into in this video, right? I'm also not referring to the movement of an asset to a spouse, because there's some rollover relief that we're not going to refer to in this video. So this is primarily those assets and those properties that are investments and that you want to pass on to somebody else before you pass away. And the reason why you'd want to do that, for example, is family disputes and family frameworks. That's just one example, is when your family dynamic maybe involves ex-spouses or multiple children or children from other marriages, and you are aware that this could cause potential disputes in the future. This is a fantastic way of making sure to avoid those disputes and deal with them now, as opposed to leaving them until you pass away and leaving everyone in your executor to have to deal with them then. So that's just one reason. Another reason, for example, is the operation of this asset. Now, operation of the asset basically means that maybe it's an income generating asset and you feel that your kids are better suited to operate this asset. That's a very good reason as well. Maybe you want the children to benefit from the income or the capital growth of the asset. Maybe you want to give them the assets so they can leverage it, raise finance on it, and actually go and use that money to invest somewhere else. There's a variety of different reasons, but whatever that reason is, right, make sure it's not only tax planning, right? So what are the real costs? Now, the real costs from a tax perspective involve donations tax, capital gains tax, transfer duty, and a little hidden trap that I call the Section 7C loan trap that a lot of people struggle with, right? Now, there's two ways that one usually goes about in normal planning of transferring these assets across. The first way is by way of a donation. The second is by way of a sale. Now, a donation, everyone knows you pay donations tax. It's 20% on the value of the property. That's a big amount. And on top of that, you're paying capital gains tax as well. You're paying transfer duty, and you're probably paying the conveyances fees to move the property across. So it does become expensive because there's donation tax involved. So everyone automatically seems to lean towards selling the property to their children. And either they sell it outright and their children raise money and pay them in cash, or they do it by way of loan account. Right? Now, this seems like a great idea, but the first thing that I have to mention here is that unfortunately, if you sell the property and the money isn't received immediately, right, the loan sits as an asset in your estate. So you're basically moving one asset for the other. So be very careful, because you're not going to save on things like estate duty. You're just moving the money across. Even if your children do actually buy the property out and give you cash for it, that cash still sits in your estate. So it's still basically counted towards the value of your estate in calculating estate duty. So be careful with that. You have to plan ahead, because you are going to be receiving something in return for the property, whether it's now, whether it's later. So plan ahead. Fortunately, if you're receiving cash now, you can utilize that cash for your well-being. So usually this is quite a good idea, because you take that cash and you actually put it towards your retirement, and you use it to supplement your lifestyle. If you do it on loan, however, you're getting no direct benefit. You pass away, this loan possibly sits as a claim against your children in their estate, which then carries other consequences, tax consequences, when eventually it has to be written off, potentially, or it has to be taken into account when it comes to distribution of assets when you pass away. So I would be very wary simply doing it off a loan account unless the property actually does generate income and there is a way to pay off this loan account over time and write off a portion of it also over time. Again, the planning is crucial. So depending on what your circumstances are, you might be able to do this and eventually reduce this loan over a period of time. So keep this in mind. Keep this in mind in the planning stage. Under both circumstances with donation and sale, there is going to be capital gains tax. There will be transfer duty. There will be transfer fees. And so what's the Section 7C loan trap that I speak about? So what this is when people were trying to do structuring, so instead of moving the assets directly to the children, they move the assets to the trust for the benefit of the children. So it almost feels like it's the same thing, right? But in our law, it isn't, because a trust can be its own taxpayer, right? And now Section 7C, when people started seeing that individuals were doing this, why would they do this? Because a trust doesn't always pass away. So under certain circumstances, you can avoid paying estate duty if you move things into a trust, because at least then it sits in the trust, and when you pass away, the trust doesn't pay any estate duty. So what SARS did in these instances, because people were now actually donating to the trust, but not paying donations tax, so doing it by way of a loan account, and SARS wasn't getting its cut, right? What started happening now was SARS introduced legislation that requires donations tax to be paid on the interest that should have been charged, but might not be, or the portion of the shortfall. So there's a prescribed interest rate on the loan account that SARS expects you as a seller to charge. If you're not charging that full interest rate, whatever you're failing to charge is going to be counted for donations tax. Now, this sounds okay because it's often immediately not as high as the donation tax on the full amount, but the downside is it accumulates over the years. And because it accumulates over the years, you need to be very careful because it might land up costing more over time. So again, there has to be a proper plan of action to ensure that this loan can be repaid and or written off over time in order to reduce that interest cost, or to justify not paying donations tax. All of these aspects have to be considered when doing this sort of planning. And the take home is that the planning should not only involve tax planning, but should also involve planning from all the other varieties, including the family dynamic, which is absolutely, absolutely crucial, because the amount of disputes that erupt between family members after one's passing away is extraordinary. And it's one of the most common features in estates where litigation attorneys have to get involved. But aside from that, if you have any questions, please pop a message below or comment below, and I'll answer it as soon as I can.